Okay, well, we'll call the committee to order. This is our new home for election law and several of the other committees. The way that this is probably going to work out in the future, the Senate will pretty much exit the LOB even after the construction. So this may be our home for the not only near future, but far future. So we'll see what happens. All right, and with that, the first bill in front of us is Senate Bill 435, and I believe that the prime sponsor is ready to introduce it.
Morning, Mr. Chairman, members of the committee. I'm Senator Darrell Abbas. I am here to introduce Senate Bill 435. And what this does is makes an adjustment to the criteria that one would seek when they're requesting a variance before the zoning board. Very simple. It's a 5-part criteria. You just make it 4, eliminates the hardship criteria, which is the 5th prong you would have to satisfy. As you all know, to get a variance, the applicant or the petitioner would have to satisfy all 5 of the criteria. This would just make it a 4-part criteria. The other 4 are left unchanged. Particularly with the hardship, what I felt from my own personal observation, it was not always consistently applied. I've seen some boards perhaps struggle with the meaning of what a hardship is and is not. With that being said, if you look at the other parts of the criteria, they seem to really protect the abutter, right? Whether it's, does it violate the essential character of the neighborhood? Does it create a safety concern or risk to public safety? Does it devalue the abutting properties? All those are to protect the abutter. Whether you have a hardship, which is a special condition unique to your property, the way I look at that is, that whether you have that or not doesn't impact the abutter in any way. A special condition, I always say the easiest example is if it's, let's say there's 12 houses on a neighborhood and it's a cul-de-sac at the end. Well, the house at the end may not meet the frontage criteria because their front yard's kind of on a circle. That would be considered a hardship per se. But whether you meet that frontage or not, I'm not sure why it doesn't really impact the abutters or hurt them in any way, whether you get a variance or not. The other 4 protect the abutters, and that's what they're designed to do, and protect the community. The hardship, I always say if an abutter shows up and they oppose your petition based on whether you meet a hardship or not, they just don't like what you're doing, because that has no impact on them. The other ones would, obviously devaluing property and the rest. So I think it would maintain local control still. It doesn't take anything away from that. The decision's still made at the local level. It's just whether I think this will lead to less litigation. I think less people are going to file claims, especially when you see this provision by the same board applied all over the place. And I've seen it with my own observation, so I'll be happy to answer any questions.
Questions from senators? Senator Delaney.
So, as a former zoning board chair, my question, they have another bill over in energy there. They texted me and tell me you got one more speaker. So the hardship requirement is generally used when the master plan is, or the zoning laws have set requirements and you're coming in for a variation because you don't meet a given requirement. One of the reasons you may meet it, I'm going to use wetlands because that's the most common one, is that the wetlands makeup of your property, unique to your property, created so that you can't you have to be encroach within a certain abutment, right? You have a 10-foot buffer, but you can't put your building any other way but to encroach into 8 foot. And therefore, because of the makeup and the hardship of your land, the layout of your land, you're asking for that adjustment and say the law is this, but I can't meet that law for this requirement, and therefore I'm going to ask for an adjustment. That's generally a hardship adjustment.
See, I don't agree with you because first of all, you can just build a smaller house and therefore meet that setback as long as you meet all the other criteria. But every petitioner has to demonstrate that there's a hardship to get a variance. And that's my point, is that if you look at when these are allowed, how many of those properties each have something that's very unique about just that property, different from the surrounding properties, right? Which means you have to be the only house or lot on the street with this wetland problem, and you can't really build anything else other than what you can build a smaller house. I mean, that's the thing. You still can use it for its intended purpose, which is, or intended use, which is residential. Your master bedroom may be smaller. So people go for variances asking, well, I want this because this is what we want to build. Granted, it's a better house. It obviously makes a more valuable house that actually benefits the abutters. Again, why they would oppose something that would increase their property value, who knows? But my point is, everyone has to demonstrate a hardship every single time. I'm talking specifically, I mean, there's some equitable issues, that's a different standard, but this doesn't impact that.
Well,
So again, though, what you're saying is, again, as a zoning board chair, I always work to get to a yes, right? How can I let the the person who wants to do something with land be able to do with their land? So let's try to get there. And sometimes that means we waived, due to hardship, we waived that 10-foot setback and made it only an 8-foot setback. Sometimes that was, we looked at it, we agreed, you can't do this any other way based on the nature of your land. Not about your butters or anybody else, but about the nature of your land. We agree you could shrink it, but again, that's an impingement upon the landowner's
You're
rights.
still going to satisfy the other four, though, is my point. Meaning, you may say, 8 feet instead of 10 feet, fine, but you still have to demonstrate it's not going to alter the essential character of the neighborhood. You still have to demonstrate it doesn't create a public safety, concern or any safety issue. You got to demonstrate it won't devalue the abutting property. You still have to demonstrate all that, whether there's a hardship or not. You still have to make the other demonstrations. You can't just grant a variance simply because there's a hardship. That's not the criteria. You need all 5. And I'm just saying, and respectfully, based on my conversation with you, and I'm not sure if people can understand what we're even talking about, is a lot of confusion with how this should be applied. I'm not saying every board every time misapplies it, but I think it's going to be a much cleaner process. And I think with a lot of the housing bills that we saw last year, what inspires that is when people go before these boards and they see that. I can give you an example. The last time I went in front of the ZBA, a member of the board sent an email to the town. It wasn't myself, it was a family member. Sent an email to the town planner that they didn't think he met the criteria. Now, it's a predetermined conclusion. They should be disqualified. Well, we asked that person said they'll step down or just recuse themselves if asked. When my mother's attorney asked that person to recuse himself, they then changed their mind to it. I'm just saying that people are losing somewhat of faith in the process, and I look at the hardship, watching it be applied all over the place pretty consistently as one of the reasons why we have these bills. I think if you eliminate that, you're still protecting everything that you have zoning for. I don't think the hardship's necessary to maintain that.
So what's the point of having a zoning ordinance at all? If you're just going to grant it because no butter cares, so I'm just going to grant it because we just won't give a rule.
Well, that's
We don't need things like setbacks because we're going to waive it anyway if you meet all the other criteria.
Well, but you can say that with or without the hardship, you can grant a variance, right? If
But you wouldn't
I mean,
need
if you
variance
have
if
the
you don't-
criteria or not, you still have to file the petition,
I think
do what you have to
I
do.
think we're replowing the ground again here, so
Well, you asked the same question.
again, that's why we're gonna
Same
move
question,
on.
same answer, Mr. Chairman.
Other questions from other senators?
Mr. Chair, excuse me, I got to run over to energy. I'll be back.
Amen.
Thank you. Please vote on to pass.
All right, thank you very much. Margaret?
I like that moving, the chair. All right, good morning. I'm Margaret Burns, representing the New Hampshire Municipal.
Oh my goodness, I have to get back into using these microphones correctly. Welcome back to the session. I'm Margaret Burns, representing the New Hampshire Municipal Association, here in opposition to Senate Bill 435, which would repeal the final of the 5 criteria in the variance statute. Variances exist essentially as a safety valve to prevent an unconstitutional taking of property as a result of how a zoning ordinance is applied to a particular piece of property. They are not supposed to be easy to attain. And the reason for that is because the property owner is asking for permission to deviate from the regulations that apply to everyone else. So there is a very high standard for achieving a variance, and it is appropriately a high standard, but it is also critical that the law allow for variances so that an unconstitutional taking does not occur as a ordinance is applied to a property that may have unique and special circumstances that make the ordinance a substantial hardship to that particular property owner. The five variance criteria are designed to identify these special cases where there are unique circumstances that apply to the land, and the unnecessary hardship criterion is a key component of the test because it is the part of the test that ties the zoning ordinance to the particular piece of property. So it ensures that that the variances are not being granted in an arbitrary manner, that there is a justifiable reason, and that the reason is connected back to the specific attributes of the property. Now, the term unnecessary hardship, I admit, is not crystal clear on its own, but when you read further down in the statute does establish the two ways in which unnecessary hardship are to be established. And that language is certainly clearer than what you see in section E alone. So you have to continue to read the two tests that are used to establish whether an unnecessary hardship is established. The first test, basically the way it works is you start with the first test, and if the applicant does not meet the first test, only then would the ZBA move on to determining whether the second test is met and whether the variance can be established. In the presentation of the bill, there was some conversation about how the other variance criteria seem to be more focused on a butter impact. And there is that portion of the variance criteria that's focused on how granting the variance would affect the community, how it would affect the property values of surrounding properties. But that's why the fifth criterion is so critical, because this is the part where the Zoning Board of Adjustment looks at the circumstances of this particular piece of property and makes that decision about whether the variance should be granted in these circumstances. So for that reason, we oppose the bill repealing the fifth criterion of the unnecessary hardship test. Thank you very much.
Questions from the senators?
Yeah.
Senator?
Thank you, Chair. I'm intrigued by one piece of what you said, which is that this criteria ties the decision to the land. Can you just elaborate on that? Yeah.
Thank you. It ties the decision about whether a variance should be granted back to the unique circumstances of this property.
Okay.
So why in these circumstances should this property owner be allowed to deviate from the rules that apply to everybody else? And that's why a variance is a substantial decision that's made by the ZBA, but that's also why it's critical. Why can my land not be used in a manner that doesn't arise to an unconstitutional taking, essentially?
Sure. And just one more follow-up, if I may. Okay, that's helpful. And then, being the municipal association, you're probably more, this microphone's funny. You're probably more familiar with the case law than maybe some others. Ultimately, in your opinion, does the case law come out to a reasonable balance in terms of how to apply unnecessary hardship? Or, could there be some improvement? I guess I would just welcome your opinion on that.
There is nothing easy about assessing any of the criteria of the variance statute. It is a complicated area, but the case law is fairly extensive, and there are excellent and clear and well-reasoned decisions that have come out of the Supreme Court that give ZBAs guidance in how to apply the variance criteria, including how to apply the unnecessary hardship test. It takes some training and some learning to get a good grasp on the criteria, but the decisions do come out in a way that is educational and helpful and gives the appropriate guidance for understanding the statute.
Okay, I'd be interested to see anything you'd be willing to share with us.
Yes, the Simplex case and then the Ocean something case that is not coming to my mind at this, and a great case out of Portsmouth that is also eluding me on a sign variance.
Questions from
Thank you.
Senator Long?
Thank you, Mr. Chairman. Thank you for your testimony. So the applicant needs to show their special, how special their property is that they can't conform with the variance. So if we were to eliminate the hardship, would it be less about their property?
In a way, yes. In a way, it would be, because they wouldn't be establishing why if they are not given this permission, they will suffer essentially a taking of their property by having to comply with the zoning ordinance. So in a way, yes.
Thank you.
Senator?
Thank you, Mr. Chairman. So, having been on one of these boards for many years, you talked about the criteria that are met. The previous criteria, the 4 prior to this, are very objective. I mean, we could go through and definitively assign, a yes or no to this. We got hung up on this last one a lot.
Yeah.
And I think you even said that. I mean, you said it's not as clear as it could be. Is there a way that we could make that clearer so we could, you heard the testimony from the prime sponsor and some of the subjectivity that gets put into that. Now we're here talking about this. Is there a way we could clear it up?
Possibly. I think that the language that we have in the statute now comes from years of careful consideration and ruminations and decisions by the Supreme Court that have ultimately led to what we see in the statute now. A lot of smart people have tried to make this language the best that it can be, but that doesn't mean there isn't room for improvement. I think what I would be interested in is, do we want to try to improve the language that's in the 2 tests that fall under unnecessary hardship? Are we focused on section E, which is sort of the heading of the criteria, which says the unnecessary hardship part? Is it a full rewrite? Certainly, I am willing to be helpful in trying to clarify that criteria, and if that is the will of the committee. I think it's critical that we don't repeal it entirely.
Thank you.
Yeah, thank you.
As I sit here and listen, I'm also interested in the grandfathering in the future. Is that it would seem to me that the discussion over, and I don't like the word hardship, the condition of the land, which would say that we should change the regulation, that discussion also gives me an insight in the future as to what hardship, or should say what is grandfathered for that land. So I don't know if you want to speak on that, or.
I think I need a clarification.
When I grant a variance, that
Yes.
variance goes with the land and
Yes.
stays with the land.
Yes.
To understand what that variance really is, it would seem to me that the discussion of, in the now's words, the hardship, now defines what's going on. But if I take away that criteria and I'm only using the other 4, do I still have a good idea of what is grandfathered? What is the now?
The sort of vested rights.
Yeah.
In that parcel.
Oh, interesting.
Again, it's,
Yeah.
it's something that just came to me while we were talking.
Right.
We won't make you answer.
No, and I suppose in that circumstance, I don't think I'd use the word grandfathered in that circumstance, because once you get that permission, now that's part of what you're allowed to do with the property, and usually grandfathering is referring to doing something with the land that predated a regulation, and you're allowed to continue to do it even after the regulation comes into play. But I would have to think about that. Absolutely.
All right, additional questions from the senators? Seeing none.
Thank you so
very
much.
Tom? Tom? DeRosa?
It's not speaking.
Oh. I didn't look far enough. Okay. All right, Joni?
Good morning. My name is Joni McIntyre. I'm a real estate agent here in Concord with Coldwell Banker J. Hampy Associates, and I'm here representing the New Hampshire Association of Realtors as the Vice Chair of Advocacy of Public Policy. I'd like to read you my testimony, and if you'd like, I'll give you an example of something I'm working with.
We do ask that you summarize your testimony because you're going to hand it to us and we can all read. And the Senate rules do ask that you summarize the testimony and not read it.
Okay. So, based on our experience, the most frustrating barrier to obtaining a variance is the hardship criterion. We were just chatting about this in the back of the room. I kind of feel like it should be the first criteria because you wouldn't be probably looking for a variance if you didn't have a hardship. All of the other criteria still have to be met. And for a homeowner looking for a variance, to read through that hardship criteria, very difficult to understand. And so I think it would be a very slight change that will make that variance process easier for homeowners or property owners. Let me just see. In most situations, those variances are asked for because of a small issue, a small amount of frontage, a small amount of square footage, that type of thing. Right now, I have some buyers who are looking at a property in Concord. They own in Concord. They'd like to sell their very small house, and they've found this house that was built just within the year on a very small lot. Upon investigating, I found out that they had to get a variance to get that. They had to meet all of the criteria. The lot was subdivided prior to zoning. And so that was one of the criteria that they used to say, yes, that this was already done. We should be able to use this lot for a single family home. In the end, they were granted that. But I think the hardship is sort of intuitive. Of course, there's a hardship. We have to go for a variance. And so we feel like the realtors feel that property owners should be able to use their property to a way that works for them, and as long as they've met all these criteria.
Questions from senators? Seeing none, thank you very much. Anybody that didn't testify that wants to testify? The online signups were 3 in support, 1 opposed. Yes, ma'am. You want to pass that down to her so she can put her name on there?
I apologize. I was here early too. Good morning and thank you. And I apologize for that oversight in signing up. My name is Diana Lush, Raymond, New Hampshire. I did serve as planning board chair for 3.5 years and, planning board for 3.5 and chair for 2+. My husband actually sits as the ZBA chair. And we just finished the town report for Raymond, and the variance requests were 5, and 4 were granted. Only 1 was denied, and I don't think there was any surprise to that one. So I don't think variances are that difficult to achieve. When we moved to Raymond, we actually had to file for a variance as well for our property. We have a large pond, and it prohibited parking spaces for us. And the town assisted me because the language gets confusing for the layperson. But they were very helpful, and I did a lot of research, presented my application, and the ZBA granted us our variance. So I don't think it's a huge hurdle. I think that the hardship is the key component, as the Meg mentioned from New Hampshire Municipal. It ties that property to the zoning regulations, and we know why we have regulations. We all have to live in this community. We all want clean water. We want to make sure that the use of that land is appropriate. And I think this could lead to overcrowding. But more importantly, I really feel variances are not that difficult to obtain. And I believe it was Senator Lang said you sat as well on the ZBA. And I do feel that they do start out with a how can we get them there attitude. And there's a lot of training for ZBA members, and we enforce that in Raymond as best we can to make sure that they all go through training and through legal training, New Hampshire municipal training. So if that's where maybe we need to have more focus, I would applaud that, so that the layperson that get elected or appointed to these boards understand the criteria as well. But the last part of this is sitting on the planning board. We often went back to the year in review of ZBA variances, and as a planning board, if we saw a multiple of variances being requested that they were the same, we would propose putting a warrant article to maybe relieve the zoning, so that people didn't have to keep coming back for the same variances. So through warrant article, we did that to, again, make it more friendly to our neighbors. Thank you for your time.
Questions from senators?
I do have one question.
Senator?
Thank you for being here. Thank you for testifying. In the environment where, we are looking at a housing shortage and we do want to make sure that we're sort of finding the highest and best use for our lots, would you still think the balance comes out in terms of retaining this criteria, knowing that sometimes creative housing development might mean that a parcel doesn't have quite the right setbacks or, frontage? Just sort of where would you come out on that balance?
I would say from all of the ZBA hearings that I have witnessed and or been, present at, and even through planning board, your typical homeowner that's going for these variances are not developing their land. They're single lots, and if they need a shed, 10 feet instead of the required 15 feet, they're getting that variance because there's ledge. They can't build maybe their garage on this side of the property because of a lot of ledge. They're getting those variances. I think a developer is a whole nother aspect, and that's where we dealt with them with the planning board. But they have engineers, they have the capacity to manipulate the lots before they even come in, and most of them don't need those variances to get the more housing on a piece of property.
Additional questions? Oh, Senator Long.
Thank you, Mr. Chairman. You mentioned there were 5 ZBAs. 1 wasn't granted. Was it a hardship reason
don't have
that it
the-
wasn't granted? Oh,
I'm sorry, I only have the chart and the total, the summary,
that's fine. Thank you.
but I know that it was not. I think the applicants kind of knew they were stretching, and it doesn't mean they can't come back and ask for something else,
Additional questions from senators? Seeing none, thank you very much.
Again, thank you so much.
And we'll close the public hearing. We'll open the next public hearing in just a second. you. Okay, we're ready to go. Senator, introduce your bill, please.
Morning again, Mr. Chairman. I'm Senator Darrell Abbas. I represent District 22. I'm here as the prime sponsor of Senate Bill 436. And this has to do with when there's a conflict of interest, or if a member of the ZBA should otherwise be disqualified, whether they have a predetermined conclusion, a bias, some type of inherent interest in the petition that's pending before them. Although the existing RSA uses the word "they shall," the problem that occurs, and what I've seen twice, is that first of all, the board can make an advisory recommendation to that member if the issue is raised. It has to be, the RSA said it must be raised by the board, and then you can have a situation where 4 out of the 5 members may vote one direction. However, it's not requiring or mandating that person actually recuse themselves. I think it's something that if they have first of all, an advisory is not binding on anyone, but if they have any type of conflict, if it's raised, they should not be sitting on it. The same way a judge would not sit on a court case if they had the same situation. So I believe they should be held to the same, because it's a quasi judicial board, it should be held to a similar standard. I think as written, I'm not 100% this meets the mark, what I was going for. So I may offer somewhat of a redraft of this, but the goal is that if there is a board member that is disqualified for any reason, they shouldn't be sitting on there. There's alternates available, at least I hope they are, but they should not sit on this. That would get overturned on appeal in a second. The leading case in New Hampshire, I don't recall the citation, but it was actually the planning board, not the zoning board. But even though it was whether it's a 7-1 or 8-1 decision, simply having a biased member on there, they say kind of may influence other members of the board. It's still not, they should still not be on the board for that reason. I think, again, the integrity of these boards, many of them don't have legal backgrounds. Many of them are lay witnesses. So expecting them to then vote amongst themselves whether someone else has a conflict or not, when it's raised and if it's apparent, the board member must recuse themselves, not simply have the option. They can't. The board can't actually make the person step down. However blatant that conflict is, and that's a problem. So this would change that.
Questions from the senators? Senator Long.
With respect to this, is this just for the ZBA and the Building Code Board of Appeals, or does it include planning?
This is, I believe, this is just under the ZBA.
Okay.
But I'm not sure you're suggesting this, but whatever standard there is, it probably should apply to both. I think that would make more sense. I think if there's, again, the case I just referenced was a planning board case, but it was the same rationale. It's like, well, that person's on the board, they have a conflict or whatever, and they should have recused themselves, but they still voted, but they sat through the hearing and still kind of, it's like in a jury, you can't have that either, right? And that's an automatic mistrial. You get a new trial if it comes out even after the fact.
Okay,
So,
follow up if I could.
Yep.
So, I was 13 years on a planning board as an alderman rep on a planning board. And a lot of times we would approve a planning, we would approve the applicant, and then 6 months down the road, there'd be a vote from the alderman on a specific criteria with that. So it would be something that you would know about, or, for example, a planning board chair may say that's up to the board of mayor and aldermen to make that decision. So at that point, would a planning member that happens to be an alderman recuse himself because of that?
So I understand the idea of, do they have a predetermined conclusion? It certainly could be raised. I think whether you support something, it depends on, I think, the specific facts of that and how you arrived at approving it as in the capacity as an alderman than as a member of the planning board. So I think one of them is more like budgetary in its implementation, where the others, applying a legal criteria. you may meet one and not the other, but again, that gets a little, that is a gray area.
Okay, thank you.
Senator Delaney.
Thank you for your question. So section 5 that we're talking about here, if I remember right, this is a section we amended last year to deal specifically with zoning board members who are also planning board members, and especially where they're acting in a quasi judicial manner in which where someone's challenged a ruling of the planning board. And to have the planning board members already voted on this again, vote again and influence the committee, I think we decided it was inappropriate. Were you aware of that we just literally went into effect July 1, 2025?
Yeah, yes, but that is a completely different scenario than what I'm talking about.
Except you're repealing and reenacting,
Well,
taking that away.
the RSA, I think that needs to be addressed, and I mentioned that this may not have landed the plane the way I wanted to, is actually RSA 673:14. That has to do with disqualifications of members. So I think this as written is not ready for prime time, but under that RSA, it talks about the advisory that can be made to the other board member if the issue is raised, but that has to be done by the board members, unless the local municipality adopts a separate procedure. And if there's an advisory for that person that they have a conflict or not, again, they don't actually have to follow it under the law as written. It says they shall be disqualified, but when you raise this, it's just like any other objection. It's quasi judicial board. If you don't raise the objection right away, it's considered waived. You may not know about someone's bias or disqualification at the exact time. So the fact that you don't know about it, you're considered to be waived it. But I think that's an unreasonable standard to hold someone to. I think in reality, if the member sitting on the board is disqualified, they have the obligation to step down, and that should be it. And that's what I want. I think cleaning up that RSA to make it a mandatory, no exception, they would recuse themselves. That's a fairer process. And we don't have that with jurors, and we don't have that with judges in actual courtrooms. It shouldn't be like that on the ZBA or the planning board for that matter. So this means a little more work, but I would just suggest reference the RSA I just said. It was
One follow-up. So the language in this bill, especially on line 5, impartiality might reasonably be questioned. Isn't that opening up to any allegation automatically requires a recusal?
well, when it says reasonably, it depends on what they're saying, why you're impartial. Again, you would need it's very fact specific.
But again, a follow-up, you use the language on line, any circumstances in which a members might reasonably be questioned. So again, it opens it up to every allegation might reasonably be determined the person's impartial and not impartial, and would require recusal of everybody, whoever, once there's an allegation made.
I mean, in fairness, I can say no one here is impartial because they sat on boards before. I wouldn't go that far, simply because it would have to be something that it shows that it actually impacts their ability to be, fair and not biased towards a predetermined conclusion. Just because you happen in a smaller town, just because you know the person, if they're your good friend, it's different. But just by simply knowing the person, I wouldn't say it would make you impartial. If your family member lives next door to that person, it's getting closer and closer. I had one. It wasn't even in the state, but the person involved in the case, who was a alleged victim, it turned out was the judge's daughter's roommate in college, and they didn't know that right away. But once it came up, it was no questions. It was like just because the appearance and the judge, I don't think even knew this person very well, but just because of the appearance of it, it was. I agree with the decision. So yeah, no, that makes sense.
Additional questions? Senator Perkins Roca.
Yeah, thank you, Chair. I mean, I guess from a drafting perspective, you're taking out the existing language, which requires recusal when someone participated in a quasi judicial capacity in the decision previously, and you're replacing it with language that requires to recuse when there's a conflict of interest, which is defined in part by participation in a quasi judicial capacity, but just sort of also adds this questioning of impartiality. So I do. I appreciate you're trying to redraft it. Are you going to try to define conflict of interest more specifically with your amendment?
So first of all, I think I would jump to a different RSA, and that's again 673:14, which has to do with disqualifications. So I would leave 673:3 as it's written today.
Okay.
Because I think that's what my friend from Manchester brought up. You know, if you're sit on one board in a different capacity, are you now conflicted out? I'm not trying to address that. That's a different issue altogether. So I would ask you to, if you cannot act on this, and I provide an amendment to the committee at a later time.
Okay. Okay.
Should there be a provision in here that allows the people to waive the conflict? If I'm on a zoning board, planning board, and I only have 5 members present, you know, it's a tough criteria when I don't, and I may find it better to waive it. So should there be provision in there?
So I suppose you could allow for that exception. The problem is it's deemed waive if you don't raise the objection right away. So that's when you allow that waiver, and it's not always clear to the person that the conflict exists or that any impartiality exists, or it may exist to some degree, but maybe you don't understand to the degree it may impact the board member. You're not required to have 5 members sit on the ZBA. You know, it's what you really only actually need is 3. The downside to that, Mr. Chairman, is you need if you're trying to pass something, if it's only 4 present, you're gonna need 3 yeses still. So myself, if I was the petitioner, I would want 5 sitting there. So I see the problem you raise. I don't know. I hope
If you were going to write an amendment, just consider it.
you would want, that would be very favorable to the chairman's decision. I understand.
Are there any other questions from the senators? Okay, seeing none. Margaret?
Good morning again, Margaret Burns with the New Hampshire Municipal Association. We are opposed to Senate Bill 436 for 2 primary reasons. The first is the vague language, specifically the standard that the quote members' impartiality might reasonably be questioned is vague, especially as compared to the existing statute, which uses the juror standard, that there's a direct pecuniary or personal interest in the matter that would create the conflict of interest. The second has already been raised, that it is in conflict with or duplicative of RSA 673:14, which already sets a conflict of interest standard for all land use boards, ZBAs, planning boards, and everyone else. So if this were enacted as drafted, it would create confusion between those 2 sections. Additionally, I just want to add that even though the language of the bill says shall recuse him or herself, the language of 673:14 says shall not participate. They are in fact the same thing, the shall not participate and the shall recuse. The reality is that the onus of recusal is always on the land use board member. No one can physically force a land use board member to actually recuse him or herself. But the reason that 673:14 has the advisory vote is if the board believes that this person has an issue and has a conflict, and perhaps they're not taking it seriously, or they don't understand that it really does rise to the level of conflict, that at least gives the board the ability to take the vote and advise that member that they really do need to recuse themselves in the board's opinion. Because as has been noted by this committee already, even just one conflict of interest can blow up an entire decision on appeal and require it to go back to the land use board. So for those reasons, we are opposed to the bill, and I am of course happy to take any questions.
Questions from the senators? Seeing none,
Thank you.
thank you very much. That's the last person on my list. The sign-ups online, there was no one that signed up on this bill. And unless there's somebody who has changed their mind, we'll move on to the next, close this hearing. Senator Altschiller is away today. I've told her that it is not my intention to exec this bill today and that she will be given a chance to speak during the executive session when that happens. And so we'll let you introduce the bill for her.
For the record, my name is Kevin Condict. I'm the Minority Caucus Director in the Senate. I'm here to introduce Senate Bill 439 relative to municipal data center zoning. Senator Altschuler has given me copies of her testimony. She asked me to read it, so I'll get started. Zoning in New Hampshire can be described three ways: local, local, and local. Every municipality has its own character, but zoning's purpose remains constant: to promote the health, safety, and general welfare of our community. As data center development accelerates nationwide, we face a challenge our existing zoning codes weren't designed to address. Data centers don't fit neatly into conventional commercial or industrial categories. Their distinctive combination of high energy usage, low employment density, and significant infrastructure requirements creates a unique building type that challenges traditional classifications. Many jurisdictions currently treat data centers under vague classifications like light industrial or technology facilities that fail to account for their specific impacts. This ambiguity creates delays, community conflicts, and unpredictable outcomes. Data centers represent one of the fastest growing sources of electricity demand in the United States. The Department of Energy projects consumption will rise from 176 terawatt hours in 2023 to between 325 and 580 terawatt hours by 2028, potentially doubling or tripling their share of U.S. electricity consumption. This isn't theoretical. A 2024 analysis found utility load growth forecasts jumped from 38 gigawatts in 2023 to 128 gigawatts in 2024, driven primarily by data centers. In Virginia, growth in data center power demand exceeds the capacity Dominion Energy can provide, creating transmission line and substation shortages. This bill's requirement for written utility confirmation ensures adequate electrical capacity will be available within 2 years of construction. This protects our grid from overload, ensures reliability for existing customers and community services, and benefits developers by identifying capacity issues earlier rather than after significant investment. Data center noise pollution has emerged as the primary source of community opposition nationwide. Facilities generate continuous noise from cooling systems, HVAC equipment, and backup generators operating 24/7.
Mr. Chair? Can we have you summarize the testimony?
Absolutely.
We already told some
Absolutely.
other-
Yes.
Let me weigh in on this.
I
All
can
right.
finish for 1 second, Mr. Chair?
If the chair is ready to rule,
Okay.
okay? The reason that I allowed this one to be read is because I did not inform the senator that the testimony should be summarized. This will be the last time that I accept one of these from, this way, okay? So I am going to let him continue to read it. Read it as quickly as you can.
Absolutely.
And I'm trying to be fair, but this will be the last time that, this is allowed.
Absolutely. The impacts are real. Studies document that constant humming or buzzing causes headaches, stress, sleep disturbances, and anxiety. In Granbury, Texas, Bitcoin data mining center noise led to legal complaints and health concerns. One Virginia homeowner spent $20,000 on new windows and moved an infant's crib to the basement to escape data noise center. SB 439 addresses this with a balanced, technically sound requirement. Noise levels within 300 feet of residential districts cannot exceed ambient levels by more than 5%. Applicants must submit noise studies by qualified acoustic engineers before site plan approval. This standard works because it accounts for existing background noise while preventing significant intrusion. Modern data centers can meet stringent noise standards through acoustic insulation, strategic equipment placement, sound barriers, and advanced cooling systems. Real world examples prove this after Virginia residents documented noise reaching 65 decibels at night, above the county's 55 decibel level. Amazon invested in engineering solutions that reduced by that sound by 10 decibels, cutting loudness in half. The technology exists. We simply need the requirements to ensure its use. The proposed 2,640-foot buffer from passenger rail stations and high-capacity transit facilities reflects emerging best practices. Transit-adjacent land is precious. It should prioritize high-density mixed-use development, residential housing, and employment centers that benefit from frequent transit access. Data centers generate minimal daily traffic and employ relatively few workers compared to their footprint. They represent poor land use in premium transit accessible locations. This half-mile buffer aligns with standard walkable distances used in transit-oriented development planning nationwide. Between May 2024 and March 2025, opponents blocked or delayed data center projects totaling approximately $64 billion across 28 states. In the second quarter of 2025 alone, 20 projects fell through. Common concerns include noise pollution, strain on electrical infrastructure, water usage, insufficient job creation, and impacts on property values and community character. SB 439 directly addresses these concerns. Noise control, the 5% above ambient standard with professional acoustic studies, protects residential quality of life while allowing reasonable operations. Infrastructure protection, electrical capacity verification prevents grid strain and ensures reliability. Land use compatibility, restricting data centers to commercial and industrial zones while excluding transit-oriented areas ensures appropriate site selection. Transparency and accountability, requirements for written utility confirmation and professional noise studies enable informed community input during approval processes. Make no mistake, this legislation enables economic development. It does not inhibit it. Clear, reasonable regulations provide predictability for developers while protecting communities. Virginia's data center industry demonstrates this principle despite and arguably because of thoughtful local regulations. Virginia hosts the nation's leading data center market. Jurisdictions with well-defined standards attract quality development precisely because developers know exactly what to expect. The data center industry can provide substantial economic benefits through tax revenue and job creation. However, these benefits are only sustainable when development occurs with adequate infrastructure capacity and reasonable protections for residential quality of life. We have an opportunity to responsibly encourage investment in this growth market. SB 439 provides local decision makers with tools they need to make informed choices that benefit their communities economically while protecting residents, preserving appropriate land use, and ensuring electrical grid capacity keeps pace with demand. This legislation represents a balanced, evidence-based approach. It permits data centers in appropriate commercial and industrial zones while ensuring electrical grid capacity, managing noise impacts near residencies, and protecting transit-oriented development areas. The highest performing data center markets demonstrate that reasonable regulation produces win-win outcomes. SB 439 sets New Hampshire on that path. I urge your support with an ought-to-pass motion. Thank you.
I expect the senators will save their questions for Senator Altschiller.
That would be perfect.
And we'll call
just-
DJ Burt.
Just one question, Mr. Chair. Do you need a glass of water?
I'm all set. Thank you.
Thank you.
DJ?
My name is DJ Burke. I'm here on behalf of the Business and Industry Association of New Hampshire, State's Chamber of Commerce and Manufacturing Association. I'm here today in opposition to SB 439. The BIA has significant issues with the bill as proposed, starting with the language of the bill itself, which is imprecise, and some of the definitions are very much up for interpretation in terms of what they constitute. The restrictions that are proposed here are fully arbitrary, in our opinion. And based on the definitions that are incorporated into this bill, it encompasses far more than just traditional data centers as we would think about them. I'm happy to provide examples later if you would like. On a broader scale, it singles out a particular industry, which we do not believe is appropriate in this sense. The testimony that we just heard includes an appeal to local control, while in support of a bill which is for state control. Zoning and citing facilities of this nature is a local control option, and they do the same for various other industrial uses, including manufacturing facilities, warehousing facilities, industrial sites of all types. Without state intervention, we don't believe that it is necessary in this case either. Again, this bill sends a message, whether it's in the bill or not, industry sees this as a ban on data centers. That's seems to be the intent. It has been the interpretation of a variety of businesses throughout the state. And it, again,
We're not going to attribute anything to anyone. So
I apologize.
continue.
I apologize.
Senators, do you have any questions?
Sure.
Senator
Go ahead.
Great. So I was surprised you to know that when I owned my computer company, I had a data center that had over 75 servers in it that provided healthcare services to a variety of physicians and hospitals across the state.
Yep.
And if this law would have been in place, I would have not been able to provide that service, even though it was in a downtown commercial zone.
That's correct. And we've heard the same thing from various members. We've heard from other industry professionals that, again, this encompasses, because of the way the definitions are written, it is not simply applicable to data centers as we would think about them traditionally. It also, there are numerous gray areas here. The way that it's written, the bill says that services have to be provided on site. For example, if UNH were to use a small facility and have it serve the campus, is it clear or not whether that would be considered on site or not? Again, to your point, yeah, I think it's a good one, and this is one we've heard various times. The large companies, small companies, they share these concerns because they have facilities already which fit this definition, are not anything that anybody would consider a data center traditionally. So,
Senator Perkins Coker.
yeah.
Yeah, thank you, DJ. You know, your point about how local zoning can address industrial uses is well taken, but you know, zoning rarely looks at you know, the ability of sort of electricity generation to support a use, right? And so beyond the language of this bill, I think one thing that we have seen is states try to kind of grapple with this like demand forecasting and making sure that we do have sufficient electricity supply. And I raise that because you know, we do have high electricity prices, and we do see businesses leaving the state of New Hampshire over our electricity prices. So how do we balance those, knowing that we can learn from the experience of other states? Like, are there some suggestions about ways that we could, at least at the state level, try to do some planning around the electricity demand these days?
It's a fair point, and I apologize for hopping in and out of this room. I was over in another room testifying on similar issue for net metering.
Yeah.
There are options that the state I think needs to address, and I think your point is a good one, that we've seen businesses not only who need immediate relief for some of their electrical prices, especially in the manufacturing sector, but when they're projecting out long term, the cost of energy in this state, it makes businesses ask the question whether it's viable to stay here. And again, we have seen that recently with a large employer. So I think, again, your point is well made, that electricity is a major issue, not just on this topic, but across the board in New Hampshire. And I think that is something that we hope to address as well, but in a different context.
Yeah. Okay. Thank you.
Yeah.
So
Senator
to
Lohan.
that, on this topic of electricity. So again, my concern is that we're doing an industry specific
Yes.
action here,
Yep.
when in fact a large scale manufacturing could have the same exact impact on electric rates and electric problems if it was brought into the state, and this
Yeah.
would, but this is segmenting out a specific
Yeah.
industry to say, we don't like it, we're gonna regulate the hell out of it. And versus saying as an industry as a whole and looking at the electric grid, and what happens if a large scale manufacturer comes in that's gonna create a dramatic load, and what does that mean to our substations? What does it mean to our powers and wires? What does it
Yep.
mean to our poles? I think it's a bigger issue than just this, and this is a targeted, action. Would you agree?
I don't have much to add, Senator. Thank you for your comments, and I think I would agree with you there.
Additional questions from the senators? Seeing none, thank you very much.
Thank you for your time.
Representative Thomas? I apologize for not calling you right after the prime sponsor.
And I accept that apology. Thank you. Mr. Chair and members of the committee, for the record, I am Representative Wendy Thomas, and I represent the town of Merrimack. And I also sit on Science, Technology, and Energy. And we are going to be seeing, as are you, lots and lots of bills on data centers going forward. I have been to several energy conferences over the year, and data centers are just a really hot topic. It's not regional; it is nationwide. People are concerned about these industries, and we need to proceed with caution. And I want to remind you that the town of Merrimack is the poster child for industry that has existed without any sort of boundaries or guidelines. And I'm talking about Saint-Gobain with their PFAS situation. In the summary of this bill, there are 5 things that it primarily does. It protects neighborhoods from inappropriate or disruptive development. It ensures infrastructure can support data centers responsibly. It encourages economic growth through thoughtful local standards. It improves transparency and predictable permitting, and it gives residents a voice in land use decisions. Now, I know the prime sponsor is not here, and we heard her opinion, but I'd like to go through the actual bill and point out some things. So on page 1, line 10, it talks about the local decision and control given to local decision, which is a hallmark of New Hampshire. Lines 13 and 14 talk about transit and rail stations, and there's a suggestion of 2,640 feet removed from the high transit lines. This is not an arbitrary number. This is because trains can have accidents and they can spill, and you don't want a data center, which uses a lot of electricity and to be near a spill like that. It could be a dangerous situation. Best practices suggest that data centers are located 0.5 to 1 mile away from high transit or rail stations. 2,640 feet is half a mile. Lines 15 and 16 talk about the energy use, that there needs to be an analysis that the electrical capacity shall be available to meet the projected energy needs. That's really important. These industries are energy hogs. They use a ton of energy, and we cannot run the risk of an energy industry like this not stealing energy, but using more energy than what is available for other ratepayers. Lines 18 and 19 are the noise study. We have, as the prime sponsor indicated, there are actually health impacts with the noise that is generated from these. They use a ton of computers and servers, and to do that, they need to be cooled. They're cooled primarily with fans at this point. They're looking into geothermal for cooling, but right now that is not being used across the board. So we've got fans, and I met a woman at one of the conferences. Her son lives half a mile from an energy center, a data center, and she played me the recording on her phone from this guy's backyard, and it sounded just like my white noise machine that I sleep with. This fellow, if he wants to watch TV, he has to close all of the windows in his house, and he lives half a mile away.
So in lines 27 through 31, we're talking about just noise and appearance, in that we do not want New Hampshire to look like a dystopian landscape. And then on page 2, lines 7 through 10, we go back to local control, that this is something that a community should have say in. They should have some say in how this is put in, if it's put in at all. So there are a few changes I would make to this. Again, I'm not the prime sponsor. I'm not even a co-sponsor, but in reading the bill, these are the suggestions that I would make to an amendment. That 2,640 feet, I would put at least, to allow it to be up to a mile. I would also include an environmental impact analysis that includes animals as well as wetlands. A lot of these data centers, and I'm talking large $100,000 square foot, 100,000 square foot facilities. They don't buy prime land. They buy land that is cheaper, and oftentimes they are placed on top of wetlands. We have to be very careful that our wetlands are protected in New Hampshire. I also believe that there needs to be a water usage analysis. As I said earlier, these industries use a ton of water for cooling. We need to make sure that they don't deplete the water supply for the residents, and that the water, once it's cooled, it isn't contaminated and returned to the environment. And there's also problems with heated water going back into local water supplies that are causing environmental damage. There should be a requirement that all transmission costs are borne by the data center. What happens is that these data centers are typically located. They're huge. We don't have the infrastructure right now, so the utilities come in and they build this infrastructure, and we all know that all infrastructure costs are passed down to the ratepayers, and that's just not fair. If this company wants to come in and do their business and make a profit, they should be responsible for their transmission costs. Another criteria that has come out through the conferences that I've been at is that during high capacity on the grid, there should be some sort of a switch that says priority goes to residents and businesses, not the data centers. And lastly, I would like to see a job creation report for any data center that is thinking about coming into New Hampshire. And I would like it broken down into building the facility and running the facility. I know that we're looking at building as offering a lot of jobs, especially for union builders and contractors. However, when we asked about running the facilities, we were told that for a 100,000 square foot facility, it would take 7 people to run it. So they are not the job generators that people think they are. And with that,
Questions from the senators?
thank you.
Senator Lang?
So just in terms of one of the last statements you were talking about electricity usage or electricity expansion, right? The growth of the infrastructure for electricity, you said, is borne by the ratepayers.
Transmission,
Right, is borne by the ratepayers. But you are aware that electric companies, when they do projects, whether it's manufacturing or commercial, anything else, that on-site expansion is generally paid by the developer. So if they put transformers in, if they put those things in necessarily to connect to the grid, that all of those costs are generally paid for directly by the developer who's building the property, not the ratepayers.
thank you for that comment.
A question: did you know that? It's like, because for that statement. We do it for
And you
electric charging stations right now at the rest area. So
She's ready to answer your question.
go ahead.
The key word in your comment or your question was generally, and we need to ensure that these industries, these businesses do pay for that. So we need to ensure.
Senator Perkins, okay.
Representative, would you believe that even though developers are responsible for any necessary upgrades to a substation or a transformer on site, that that does not ensure sufficient electricity supply for everyone across the grid.
I would believe that.
Okay. Seeing no other questions, I would encourage you to get with the prime sponsor because your suggested changes may not, unless you
Yep.
get another senator or whatever to do it.
Yep,
All
yep,
right,
I
thank
agree.
you.
I understand. Thank you.
Philip? Next time, spend a little more time on the penmanship.
You got it. Thank you, Mr. Chairman and senators of the committee. It's weird being so close to you guys. I'm Phil Jazak. I work for the New Hampshire Home Builders Association. You might be wondering why I'm up here. It's not necessarily in our wheelhouse at the Home Builders Association, so we are officially neutral on this bill as it sits. We would not support it as it is. But we did want to offer the opportunity to discuss an amendment. There were conversations with Senator Altschiller. So if the committee would be willing, we would be interested in helping out on an amendment that addresses
Senator Altshuler.
Some of the issues with it, including a relatively new technology known as closed loop data centers, which fixes a lot of the problems with these data centers, not all of them, but it makes the facility significantly smaller, significantly more water efficient, and significantly fewer externalities to the public around it.
Questions from the senators? Seeing none, thank you very much. And Jamie Barnett is no longer in the room.
He stepped out, Mr. Chairman.
Okay. All right. The online signups, there were 13 in support, 2 opposed, and there was no one else that signed up. So we'll close the public hearing and open the next one in just a minute. Senator.
Thank you, Mr. Chairman. For the record, my name is Mark McConkey. I represent the good people of Carroll County, of Senate District Number 3. I'm here to introduce Senate Bill 495 to increase the limit of transfer appropriation in Carroll County. As a little bit of background, when I first was elected to the House back in 2021, I, like most everyone in your first year, come to realize that you have a second job, and that's to be part of the county delegation and to work with the commissioners on that budget. I was also told when I ascended to the Senate was that one of the happiest things, 3 previous senators in my district, number 3, all told me, one of the happiest days in your life is going to be not to be a member of the county delegation. I'm here to discuss an issue we had in 2015. We came to find in 2013 that financial audits had not been done in our county since 2009. We also found that we were told there was a surplus of $4.1 million. And at that point, understanding we had such a great surplus, we then reduced, we wrote off $1.4 million to help the taxpayers. In 2014, there was a surplus of over 3.1 million. And again, we used monies for that purpose. In 2014, the delegation found out that we had a deficit of $567,000. We then, and the surplus or the deficit grew then to 907,000. To ensure financial accountability going forward, we found that we needed to handcuff the commissioners through legislation to make sure that they had to work more with the delegation, and we limited that ability down to $1,000. We have since had new commissioners in place. We have great confidence. I have great confidence in the work they're done. We have passed a number of audits. We're financially sound. And because of this auditing, transparency, professional standards in place, we're asking that we again change this LSR and give them the ability to be up to $10,000 as a line item, and feel that in light of where we are today and what the cost is of most any item with a county, that $10,000 be reasonable. And it's my hope that, Mr. Chairman, that you will pass Senate Bill 495, ought to pass.
Questions from the senators? Senator Long.
Thank you, Mr. Chairman. The only question I have is on the effective date. Do you think the July 1st? It's when the governor would sign it. I don't know if it'd be after July 1st. I don't know if it would be better to effective upon passage.
I would respect, I understand the question, and I like what you're bringing forward, and I would respect what the opinion would be of your committee. Thank you for that.
Certainly, I support the bill the way it's written, but in investigating it with Ms. Horgan, the county rep for, the lobbyist for them, I asked what the other counties were doing, okay? And so I would like you to have a conversation. Jessica, there was an email that I sent. I would like that sent out to the committee so that they will have it. But it brings into question whether or not we should go back and do what the other counties are doing, and some of them really don't have a limit to make the counties. So at least if you'd have that conversation with me and her, I appreciate that.
I appreciate the suggestion, and thank you for that.
Yep, Senator
So-
Lang.
One of the questions I was trying to think about is whether or not the future proof, which I like doing the legislation, so we don't
I
have
know.
to come back and revisit each time. Is there a way of doing this as a percentage of the overall budget so that it'll grow and adapt based on 10 years from now? It wouldn't be 10,000, it would be an adjusted number based on what the actual budget is of the county, and give them budgeting authority within a line or some other model that would be, we don't have to revisit this again. It just I don't know what the answer is. But whenever I look at set fixed numbers like this, I know we're gonna come back again at some point. Hope I probably won't be around when we do, but maybe there's a better way of doing it smarter for long term.
All right.
Okay, thank you very much.
Thank you.
Charles McGee.
Good morning. For the record, I'm Charles M. McGee, and I am the chairman of the Carroll County Commission. I've been a commissioner since June of 2023. I was appointed to replace Kim Tassari, and I subsequently ran for election in 2024 and the end of 24, and have been on the commission since 23. Senator McConkey pretty much took you through the history of why we're at $1,000 right this minute. I'd just like to add that we have a pretty substantial amount of infrastructure at the county, and it's all 24/7, 365. We run a 103-bed nursing home. We run a correctional facility. We run our own water system that supplies water to 50 residents plus the county. We handle our own wastewater and septic system, and everything's got to be going all the time. And unfortunately, as Senator McConkey mentioned, nothing is $1,000 anymore. When things go bad, it's usually lots of thousands of dollars. For those of you that may not be familiar with our budget, it's a 400 line item budget. and we do our best to anticipate the needs and which items and which lines we need the money in. But unfortunately, it doesn't always work that way. And so all we're asking is that you give us a little bit of latitude and support the bill so that we, when things come up, we can react quickly, which we basically do anyway, but it'd be nice if we could conform to the, the statute. And that's really the high point of it.
Questions from the senators? Seeing none, thank you very much.
Thank
I
you.
would encourage you also to get with Senator McConkey and look at the statute for the other communities because there really is no dollar limit that they, so. Please do that.
The only thing I would say with that is it's a great idea, but the commissioners come and go.
Again,
Thank you.
you know,
We will do that.
the dollar, well, make sure that Senator McConkey gets that email too.
Yes,
And then when you have your discussion with him, you'll see
we'll do that.
more of what I'm
Thank you so
talking
much.
about.
Thank you for your support.
All right. All right. That is the last one that signed up. Only one person signed up on the list in support. And with that, we'll close the public hearing. I'll take a motion to go into executive session just so we can have a conversation. We have a motion and a second to go into executive session. All those in favor say aye. Aye. All those opposed say nay. The ayes have it. There's a lot of things that we heard today. A lot of work that needs to be done with those things. Anyone want to speak about any of them? I'm not in favor of going and acting on any of them today because of the nature of most of them. So, but it's open for your comments.
I'll just make a comment on SB 439 for the data centers. Obviously, there's probably going to be some discrepancy in terms of what we think, but I do think trying to work on the electricity supply piece is meaningful. So I would be interested in if anyone wants to join me working with the home builders to explore an amendment.
And that offer is out there. So if anybody does, they will contact you.
So, again, so to that point, I would make it this industry specific. Again, like I said before, large scale manufacturing, large scale commercial, all have heavy electricity use that
Yeah.
will be new, especially if it's new development.
Yeah.
Is all new drags on the electricity. So
Yeah.
to make it industry specific, I think would be inappropriate, but to make it a statement about planning boards and what they need to do relative to in evaluating new development within a community. And making sure electricity is there. We do public safety, we do,
Yeah.
health and safety
Yeah.
and those kind of things. We do
Yeah.
traffic.
Yeah.
And making a different statement around planning boards saying that energy should be a consideration for a planning board.
Maybe something up to, yeah, because I know when I sat on the planning board, for example, we also had, like when Lonza came to Portsmouth, I mean, we had multiple sessions planning around their water usage. We had to upgrade our treatment center out on Pease, so I do think that there are planning functions around these that don't necessarily need to be industry specific, but that other states have been caught by surprise on. And so I do think there's a role for the state here to just help avoid other states' mistakes.
All right. Anyone else?
If I could,
Senator Long.
on the last Senate Bill 495.
Yep.
Last I knew, Hillsborough County was at $5,000. This bill just addresses the statute that's to Carroll County. So
In the email that you just received, Hillsborough and Rockingham County are addressed in there. So it doesn't tell me what the limit is, but apparently Hillsborough and Rockingham have a special section and in the statute for their stuff. So
I was interested in understanding why Carroll had. Like in Belknap, the delegation sets the limit every biennium we come in and we set our standard, right? And for us, it's $5,000.
And-
It was when I was there. So I'm just interested in understanding why we even have this one law and not let's leave it to the delegation to, as problems arise, they can adjust or lower or raise the number based on, you know, audits and other reasons and let it unique rather than be statutory.
And that was the point of my comments about, do we need this statute?
The commissioner didn't seem to be open to that.
Well, to be honest, Carroll County has had lots of conversations about different things. And there are very loud opinions, I'll put it that way, expressed. And so, you know, push comes to shove, I'm willing to do what the Carroll County delegation believes is right, as long as it doesn't go too far. And so that is the reason why I would like to see Senator McConkey talk with, and you probably should be, you know, I believe you
I don't have
represent-
Carol.
I thought you had some of Carol.
Nope.
I have some Carol.
He had some of Carol. All right, so again, those conversations ought to take place between the delegation members, the senators who represent them, and then come back with something that everybody can hopefully live with for a while. But I do agree, going from 1,000 to 10,000 may satisfy us for today, but it doesn't do anything for the future. And 7 of the 10 counties are living with the law as it is without a special section. So, according to the email. Okay. Anything else? I'll take a motion to come out of the executive session.
So moved.
We have a motion and a second to come out of executive session. All those in favor say aye.
Aye.
All those opposed say nay. Our business of the day being complete, we are adjourned.